Today's topic is the writs of Indian Constitution. The concept of writs within the Constitution framework traces its origin back to the development of legal system across various civilizations. Writs, often regarded as fundamental tools of justice and governance, have played a crucial role in shaping the relationship between the state and its citizens, ensuring the protection of rights and upholding the rule of law. Now, writs. The concept of writs plays a crucial role in ensuring the protection of fundamental rights and upholding the rule of law. The Constitution of India, adopted in 1950, provides for the issuance of five types of writs by the Supreme Court and by the High Court under Article 32 and 226, respectively. Now coming to the habeas corpus. So what is habeas corpus? It is a legal remedy which is available to all individuals. If that individual was under an unlawful detention or imprisonment, they can approach the court. Habeas corpus is derived from the Latin word meaning you shall have the body. The writ is used to secure the release of a person who has been unlawfully detained. Habeas corpus is a fundamental right which is enshrined in the Constitution under Article 32. Now, this is also can be seen under High Court under Article 226. Now, this safeguard as arbitrary detention or illegal confinement by public authorities. The main purpose of this writ is to inquire into the legality of a person's detention and make sure that there is nothing unlawful. It ensures that the persons are not deprived of their freedom or liberty except in accordance of procedure established by law. Now coming to a famous case which is ADM Jabalpur versus Shivakant Shukla. Now this case is also known as habeas corpus case. So this happened during the period of emergency in India in 1975 and several individuals were detained by the government under preventive detention laws. And these detainees filed petition under Article 32 of the Indian Constitution seeking the writ of habeas corpus and challenging the legality of their detention. The Supreme Court held that during a state of emergency, the right to move the court for habeas corpus could be suspended. The court held that even if there was a violation of fundamental rights, including the right to liberty, by the virtue of presidential proclamation of emergency, such violations could not be challenged through writ of habeas corpus. However, this was overruled by the Supreme Court in Maneka Gandhi versus Union of India, which was in 1978. In this case, the Supreme Court revisited the issue of personal liberty and spoke of Article 21 of the Indian Constitution, which guarantees the right to life and personal liberty. Now coming to the next writ, the writ of mandamus. So the writ of mandamus is derived from the Latin word meaning we command. Now this writ is a legal remedy which is available to enforce and compel public officials, governmental authorities or even lower court to perform their duties and to enforce the performance of public duties imposed on them by law. So this writ can be issued on various grounds. So the first one being the failure to perform statutory duties. So if any of these authorities have not performed their duty or failed to perform their duty, this can be issued. Also, if there is an improper exercise of discretion, this writ can be used. So coming to the case law, which is state of Bihar versus Rani Kumari case. So in this case, there was a land dispute between Rani Kumari and the petitioner, which is the state of Bihar. The petitioner had applied for a mining lease, but the state government had delayed the processing her application for several years. Consequently, the petitioner filed a petition seeking a writ of mandamus to compel the state of Bihar to process her application and grant her the mining lease. So, the Supreme Court discussed the nature and purpose of the writ of mandamus. It emphasized that Mandamus is a writ issued by a court to compel a public authority or official to perform a statutory duty which is legally obligated to perform. And the court also noted that mandamus could be issued not only against the government but also against individuals or private bodies exercising public functions. Now coming to the next writ, which is the writ of certiorari. Now, this writ is used to quash the orders of the lower courts or tribunals if the upper court found it to be beyond their jurisdiction or if it's violative of the natural justice principles. And also, this certiorari is derived from the Latin word meaning to be certified or to be informed. Now, coming to the grounds for issuance. Now, this writ can be issued on various grounds. The first one being lack or excess of jurisdiction. So, if the inferior court or a tribunal act beyond its conferred jurisdiction or exercises jurisdiction is vested in it by law. Now, error of law apparent on face of record. This means that if there is any error of law that is apparent on the face of record, such misrepresentation of statutes or legal principles. Thirdly, the violation of principles of natural justice. This means that if the decision-making process of the inferior court or the tribunal is biased, or if there is any procedure irregularities, if there is any failure to adhere to the principles of natural justice, such terms the right to be heard. Now coming to the case law. The case law is Hari Vishnu Kamant versus Ahmad Ishaq. So in this case, the Supreme Court examined the scope and application of the writ. Now, to give a background of this case, there was a dispute over the acquisition of certain properties under the Administration of Evacuee Property Act 1950. The petitioner filed a petition challenging the legality of acquisition before the High Court of Bombay. The High Court of Bombay dismissed the petition and the petitioner appealed to the Supreme Court. The primary question before the Supreme Court was whether the acquisition of properties was valid under the provisions of Administration Evacuee Act 1950. Additionally, the court examined the jurisdiction of the High Court to entertain the petitioner's challenge to a writ of certiorari. The Supreme Court, in its judgment, discussed the nature and the purpose of the writ, and it emphasized that the writ is issued by a Supreme Court to quash the orders of inferior tribunals or quasi-judicial body when they act beyond their jurisdiction or in violation of the principles of natural justice. The court also noted that the writ could be issued not only against judicial bodies but also against administrative bodies when they exercise quasi-judicial functions. Now coming to the writ of prohibition. So the writ of prohibition is a legal remedy available to prevent a lower court, tribunal or a quasi-judicial body from exceeding its jurisdiction or acting in excess of their legal authority. Prohibition signifies a judicial command restraining a court or a tribunal from further proceedings. This writ is a preventive and a protective writ which is issued by a higher court to prevent a lower court, a tribunal or a quasi-judicial body from exceeding its jurisdiction or acting in contravention of law. So this simply says that the prohibition writ is a legal remedy which is available so that to prevent the lower courts and also the quasi-judicial bodies so they won't exceed their jurisdiction and they will be acting within their legal authority itself. And this is also been explained as a protective writ which is issued by a higher court so that to prevent the lower court from exceeding its jurisdiction. Now coming to the grounds where this writ can be issued. So as we just discussed before, the lower court or the tribunal, when it acts beyond this jurisdiction, this writ can be issued. If there is any legal error or violation of procedure law by the lower court, can be issued. And if there is any injustice or prejudice if in the proceedings, then also this writ can be issued against them. So the case law of this is Himatlal Harilal Mehta versus State of Madhya Pradesh. So this case involved a dispute over the assessment of sale tax by the sale tax officer under the Central Provinces and Berar Sales Act 1947. So the petitioner challenged the jurisdiction of the sales tax officer to certain transaction be assessed. The sale tax officer, however, proceeded with the assessment despite the petitioner's objections. So the primary question which was presented before the Supreme Court was whether the petitioner could seek relief through a writ of prohibition to restrain the sales tax officer from proceeding with the assessment. So the Supreme Court in its decision discussed the nature and the purpose of the writ of prohibition. It emphasized that prohibition is a writ issued by a higher court to prevent a lower court or a tribunal or a quasi-judicial body from exceeding its jurisdiction or acting in excess of its legal authority. Now the writ of quo warranto. Now this writ is a legal remedy which is available to challenge the legality of a person holding a public office. So this asks a question of what authority that person is holding a public office. And that is what the Latin word of the meaning also is. By what authority? Now this writ inquires into the legality of the person and checks how this person is holding a public office and he is exercising a public function. So there are various. Now coming to the grounds for issuance of this writ. Now quo warranto can be issued if a person is holding a public office without any legal authority. And now the second one, if a public function is not being properly done, or if he is not qualified or appointed for that public function to be done, then this writ can be issued. And also if there is any confusion or dispute regarding the fact that if this person is being eligible for this position, this writ can be issued. Now the case that we are discussing is Madan Mohal Pathak versus Union of India. So in this case, the appointment of certain individuals to a public office were challenged. So the petitioner, that is Madan Mohan Pathak, questioned the legality of individuals holding the public office without possessing any qualification prescribed by law. He contended that their appointments were in violation of statutory provisions. So the primary question which was before the Supreme Court was whether the petitioner could seek relief through a writ of quo warranto and inquire into the legality of individuals holding public offices and are challenging their authority to do so. So in this case, the Supreme Court discussed the nature and the purpose of writ of quo warranto. It emphasized that quo warranto is a writ issued by a court to inquire into a legality of a person holding an office or exercising a public function. So in this case, the Supreme Court held that quo warranto could be issued not only against governmental authorities but also against private individuals. In essence, writs are tools for advancing justice, protecting rights, and maintaining the balance between governmental authority and individual freedoms. Thus, we